And hello, Savannah. Thank you for tuning into WRUULP, Savannah, Georgia, 107.5 FM, WRUU.org. We are Savannah Soundings, community radio with global soul. And my name is Julia M. Spencer. You have just tuned into Real Estate Real Talk, my show here on Wednesdays at noon. And I am broadcasting today again live from downtown Savannah. On today's show, we're going to be talking about Georgia rental laws. Great topic, right? Anyways, if you have listened to my show before, what I usually do is I talk dry topics such as Georgia rental laws, real estate, anything and everything related to real estate investing, specifically for the small scale investor, residential, and we also play music in between. So anything from my playlists at the moment will be played in little talk breaks, and that's what we're going to do today. So I hope you're doing really well out there on this Wednesday. You're staying safe, as you should. And I'm going to start you off with a little bit of Morrissey today. I'll be right back. Don't go anywhere. And that was some Morrissey with Knockabout World. That's where we are today. Anyways, thank you for tuning into Real Estate Real Talk with Julia M. Spencer. Got to move this around a little bit here. We are broadcasting live from downtown Savannah near Troop Square. So welcome to the show. You're listening to Real Estate Real Talk. And I'm so glad to be back in the studio. I was in New York City for the last 2 weeks. I enjoyed my time there very much every time I go. And of course, we learn stuff. We make new YouTube videos and do all kinds of real estate related stuff out there as well. But on today's show, we're going to talk a little bit about Georgia rental laws. And I'm going to also give you a couple of updates too. But before I get started, wanted to let you guys know that, guys and gals out there anyways, the viewpoints expressed in the following program are not necessarily those of WRUU, its license holder, or its staff. It's our little general disclaimer there. And I wanted to let you basically know kind of like what precipitated this show idea today, because it's kind of like a little bit of a dry topic, I guess. And I personally do not have any long-term rentals anyways. All of my rentals are Airbnbs in this county and other counties in Georgia, so this really doesn't apply all that much to me. However, when I started as a real estate investor, I did have long-term rentals. That's all I had. And so I knew these laws already, but I want to just kind of reiterate them a little bit. So we're going to talk a little bit about landlord laws and tenant laws here in the state of Georgia. But what how this basic show idea came about is basically that I taught a class about a month ago when I was in Mexico. And it was an online class on tax sale foreclosures. And one of the questions at the very end of the class was from one of my students. And he basically asked, okay, if you're buying these tax sale foreclosures at the auction, what is the minimum requirement to make them basically rentable for the general public? Isn't there some sort of federal law or like a general national law that you have to follow to make these rentals at least rentable, presentable? And where are those laws? What are they? And what is the minimum requirement, basically? And the reason that question came about is basically to see what would you have to factor in terms of costs to get a place up to that point where you can rent it and basically get some sort of income from it after you purchased it at the auction. There aren't really any national laws about this. This is all local level, maybe state level, but for sure local ordinance type local level laws, and you would have to research those individually for your area. But I did shoot the question up to my graybeard investors out in California. I talk about them mysteriously all the time. But these are people that have worked in the field for many, many more years than I have been alive, actually, and have all the knowledge and are basically walking lexicons. And I did ask, and the question came back that in the U.S., under the socialists until the socialists take over, and I'm kind of sort of verbatim reading this over here, the answer that I had, or unless you live in a socialist city or state, an occupancy permit is issued when the structure is complete. So code enforcement can declare a place dangerous and red flag it afterwards for safety violations. But barring that, and given that you comply with local regulations like smoke detectors, windows and exits being free from any kind of barring so you can exit in case there's a fire or something, you're basically free to roll until someone complains. Now, in socialist areas like some of the Chicago suburbs, for example, I'm sure this applies to New York City as well, they require inspections before sale and rental. So the best thing to check is with your local planning and zoning department on any kind of local ordinances if you're going to embark on a landlord adventure in any one particular area. So yeah, that was pretty much the answer that I got. And what I wanted to add to that is that the one thing that I do know is that in the past, I did have a Section 8 rental. It was not here in the Savannah area, Chatham County, but it was in Houston. Actually, it was Bibb County? No, it was Houston County down in Warner Robins, Georgia. And this was probably about 10, 15 years ago or so. So it's been quite a while. And at that time, I do remember that because the government, the Section 8 program, is basically providing rent payments to the tenant, that an inspector did come out pretty much once a year to look over my property. And this was their job, is basically to make sure everything's safe and nothing is, sticking out. And what I mean by that sticking out is basically any kind of like unfinished parts of the house that could damage a person walking by or something. I don't know, exposed beams or something inside the house, something like that. And so they would walk through the house basically once a year and just write you off for a bunch of stuff to fix. And then you would have to pretty much hire your own contractor to fix any deficiency and have the inspector come out one more time until they write everything or cross everything off, that everything has been repaired. And then they would basically release that account and continue making payments for that tenant that you had in there. And that is because most of the rent payment actually came from the Section 8 program for this tenant. Sometimes not all of it. It just depended on the situation of that particular tenant's financials. And sometimes it was all of it. So that was the only one thing that I actually had to really deal with a housing inspector in my entire career of renting long-term. So this was kind of like a different thing. I wasn't familiar with it up to that point. But I didn't have Section 8 rental for very long, and these days, of course, I do mostly Airbnbs and vacation rentals, so I don't have any long-term rentals at the moment, so that doesn't even apply to me. But I did want to check a little bit for the show, at least for the next 2 segments or so, about the Georgia rental laws as they're written, actually, in the Georgia statutes. And these are what I'm going to talk about in the rest of the show. They're actually state laws. They're not local laws. So the difference is that even though whatever it is I'm going to say for the rest of the show can be found in the state statutes and various other places on the internet in the law for Georgia, you should really look for your local ordinances for your local city. So City of Savannah, I did not look at any of those ordinances at all, other than the stuff that I know regarding the vacation rentals. So if you're looking to do long-term rentals here in the City of Savannah, in the local area, you would probably have to go and check with the city ordinances specifically and see how they differ, or maybe even expand on the state laws. So we're going to get to that here in a moment. It's basically going to be a little bit of a summary of some of the key Georgia landlord-tenant laws applicable to residential rental units only. And we're going to get to that right after another break song here. And of course, I didn't pull it up, so it's going to take me a second to bring it up here. Some Rufus du Sol, All I've Got. Love that song. Been listening to that nonstop while I was in New York the last 2 weeks. Anyways, thank you for staying with me here for Real Estate Real Talk with Julia M. Spencer. We're talking about Georgia rental laws today, and I'm going to give you a little bit of information about that. So we have basically a couple of key Georgia landlord-tenant laws that are applicable to residential rental units. And if you are not familiar with those and you want to read pretty much the whole regulation and all of the government regulations that are out there, and these are state regulations, by the way, not local ordinances, then you really should check the official state statutes on this and other online resources. And I can give you some of them, but probably what I'll do is this show will be recorded. It's going to be on the wreu.org website. I'll also put it on my YouTube channel, really easy to find, Julia M. Spencer. And then I'll just give you the link versus just talking about it here. But I wanted to, that's really the best place where you should go to start learning about the law. And the research, most of the research today I got from a website called Landlordology. And it was written on actually March 7th, 2014 by Lucas Hall and updated on March 13th, 2018. So it's a couple years old, but the laws don't change all that much every year. But if you want the most current version, of course, I encourage you to go to the websites of the official state statutes to get your updates. So, and you are actually the one that's responsible for performing your own research and complying with all laws applicable to your unique situation. So ignorance doesn't excuse you from following the law, basically. And I wanted to just talk a little bit about some of the basics, because I get these questions a lot. I know the answers to these, but I realize a lot of people maybe don't know this, especially new landlords that are just renting or starting to be landlords anyways. So let's talk a little bit about some of these things. Security deposits. This is a biggie. So security deposits maximum, there is no maximum in the state of Georgia by law that you can charge. So a landlord can charge you whatever they want to, basically, whatever you're willing to pay. The deadline for returning security deposits is 30 days, though. So if a landlord is withholding or claiming part of the deposit due to damages, the landlord must provide a list of the damages and the amount withheld within 3 days of you basically moving out. The landlord is also allowed to deduct from the security deposit and does not have to place the deposit in an interest-bearing account or pay you any kind of interest as the tenant. So that's pretty self-explanatory, and that's kind of generally the way it's done all over, not just in Georgia. That's kind of more the common way that it's done. However, this is something a little bit different. The landlord is required to place security deposit in an escrow account in a banking institution, but that includes anybody who is an owner that has less than 10 rental units and manages them themselves. So me, if I had like 3 units or something and I hired somebody to manage them for me, then the deposit has to go in an escrow account. But if I manage them myself, then I don't have to put them into any kind of escrow account. That's also something that really hasn't changed over the last, 2 decades that I've been doing it. So I knew this law as well, so this is good. It hasn't changed, so good. You can also charge as a landlord non-refundable fees. They are allowed by law, but they must not be part of the security deposit. So that would be things like application fees, pet deposits, and any kind of other additional fees, which are all allowed, by the way. You are required as the landlord to basically give your tenant an itemized list of move-in damages. And also, of course, when you withhold any kind of part of the security deposit, you have to give your tenant a list of the damages that they have caused and the charges for each. And without that list, you really can't withhold any of the security deposit. So if you're a tenant in the state of Georgia and your landlord basically says, I'm keeping your deposit when you move out, you better get a list of what it's kept for and how much you were charged for each item. So that is the law, just to let you know that. And that's pretty much what we have for security deposits. I'm kind of just like summarizing it a little bit. Let's talk, we're almost at the bottom of the hour. We're moving so fast here. Let's talk a little bit about leases, rent, and fees. There is no requirement for when rent is due in the state of Georgia or rent increase notices. There's no specific laws that states that you have to give notices in any special way or any kind of grace period. So a grace period basically means that if you don't make your payment by the 1st, when is there a grace period by which you have to make it by without getting any kind of late fees or something? However, if you've ever read any kind of lease agreement, you usually have something like 10 days in there, or maybe 5 days. And in my case, where I rent, I think it's like 3 days or something crazy like that. So basically, you got to make your rent on time. What I always tell my students and landlord students and anybody else out there is that it's a little bit difficult to collect on any kind of late rent fees if the account ever goes into some sort of default. So what I recommend is that you initially set the rent to a high amount. For example, if you were going to rent a place out for $1,000 a month, set it to $1,200, so $200 more than what is the going rate there. But then tell your tenant that they get a $200 discount basically every month as long as they make the rent payment by the 1st. So it's easier to justify a discount and then charge you the late fee if somebody pays late. So basically, that's kind of like a little bit of an insider trick there for landlords there. So jot that down into your book of tricks, basically. Let's see, what else is there for lease, rent, and fees? So there's no limit on a rent amount either. So no county or municipal corporation may enact or enforce any ordinance that regulates how much rent can be charged for privately owned single-family or multi-unit residential rental properties. So there you go. Anybody can charge anything. Whether somebody's going to pay it, that's another question. Return check fees, yes, but the fee is not to exceed $30 or 5% of the check amount, whichever is greater, plus the amount of any fees charged to the check holder's bank or financial institution. That's something I didn't know, actually. That's good to know. So return check fees $30 or 5%, whichever is greater. I remember that. The tenant there's actually no regulation for the tenant to withhold rent for failure to provide essential services like water and heat. However, a landlord is absolutely, totally not allowed to turn off any of those utilities. Landlord is not allowed to discontinue heat, electricity, or water services. These actions are punishable by a fine not to exceed $500. So if you're thinking as a landlord to kind of pressure your tenants to pay rent and you threaten them or even execute your threat basically to turn off their heat, electricity, or water service, you could get fined. So don't do that, please. So that's a couple of the things here for lease, rent, and fees. I got a couple more here. But we are at the bottom of the hour, and what we do here at the show here at WRUU, not just this show, but of course other shows too, we do have to play a couple of announcements, and that's what I'll do right now, and I'll be right back after that. You're listening to Real Estate Real Talk with Julia M. Spencer. We're talking about Georgia landlord and tenant laws, so stay on if that is a topic of your interest, and I'll be right back after this.
Many critical issues are facing the residents of Savannah and all Americans, including the coronavirus, homeschooling, and the upcoming general election. WRUU has 3 programs which address these issues: The Common Good on Fridays from 2 to 3 p.m., The Happy Homeschooler on Wednesdays from 2 to 3 p.m., and We the People, The Constitution Today on Sundays from 8 to 9 p.m. Stay informed about these important issues by tuning into these programs on WRUU.
St. Joseph's Candler Health System offers Johnny's Bridges to Hope program, a support group for families affected by mental illness, on the second Monday of each month. Group meetings are held from 3 to 4 p.m. at Candler Hospital. A licensed clinical social worker will meet with families seeking support in dealing with a mentally ill family member. More information is available at 912-819-8498.
WRUU 107.5 FM is a new and different listener-supported and all-volunteer community radio station for Savannah. Our diverse broadcast and web programming is supported by generous listeners who value our passion and our spunk. We're independent of other media and receive no government or large corporate support. People like you are the largest and most important source of our funding. So go to WRUU.org to find out how you can make a one-time or monthly contribution. Thank you.
And thank you for being back here with me with Real Estate Real Talk with Julia M. Spencer. And today we're talking about Georgia rental laws. we were on the topic of leases, rent, and fees. And so I got a couple more pointers here for you. One of them is that landlords are allowed to recover court and attorney fees, which I think is very good because I've had to pay those many, many times whenever I had to evict somebody in the past. So it's good to have at least that law on your side as a landlord. And the landlord must make a reasonable attempt to mitigate damages caused by lessee, but there is no statute that requires the landlord to look for a new tenant. So the way I take that basically is if somebody leaves early and kind of breaks their lease basically, I'm under no obligation to find another tenant for the remaining term. I can request the remaining terms balance from my tenant that departed early basically. So all in all, so far, if you haven't been following the show, the laws for landlords and tenants here in the state of Georgia are actually quite advantageous for the landlord. So listen up, if you're a tenant, you need to be aware of these things. Abandonment of personal property is another point I wanted to make. The landlord can remove the tenant's abandoned personal property with a formal writ of possession. That is basically a court order. And in the past, whenever I had to evict somebody, what happens is that the sheriff will come out and basically formally give you possession of your property back whenever you're doing an eviction. And then you can bring your own people, contractors, whoever, and basically take everything out of the property. It's going to be put by the street, basically. And and a lot of times, people will come and basically pilfer through it and take whatever they want, unless the tenant comes back quickly enough to recover their assets. So that is unfortunately has happened before, and that is what you actually see sometimes when you drive down the street and somebody has been evicted, all their stuff is on the street. It's probably because an eviction just happened and they just put everything by the street. That's what's done here in the state of Georgia. Let's talk a little bit about termination of a service member, and that is somebody in the military forces that is a tenant. So specific rules is that a landlord must follow a specific process for terminating the lease of an active duty member of the regular or reserve component of the United States Armed Forces, the United States Coast Guard, the Georgia National Guard, or the Georgia Air National Guard on ordered federal duty for a period of 90 days or longer. And there is a specific law for that as well. Any liability, though, of the service member for rent, as well as the cost of repairing damages to the rental unit under the lease, may not exceed 30 days' rent after written notice and proof of the assignment are given to the landlord. So, you have a couple service members, basically people members of the military, active duty or activated, even if they're a reserve component, but have been activated for 90 days or more, have special rights in the state of Georgia, which I think is also a very good law, as I have been a dependent of active duty many times. So this was an avenue, I guess, to eventually get out of our lease a little bit early if we had to, which was very good. And it's the right thing, so I believe in that. That's my point here. So let's talk a little bit about notices and entry, because that's another really big hot topic for landlords and tenants alike. Notice to terminate a tenancy at will, that's basically a lease with no end date. You have to give, as a landlord, 60 days notice to your tenant. The tenant has to only give you 30 days, so it's a little bit better for the tenant in this case. This also applies to month-to-month leases as well. Now, to notice to terminate a regular tenancy, though, on a fixed end date, there is actually no statute because typically you don't need one because the lease just expires. There are no laws for a notice to terminate tenancy week to week. Again, once it expires after the week, you just don't renew it. And the notice of date, time, or of move-out inspection, there's also no law for that as well. Now, if you are, however, if somebody doesn't pay the rent, so basically this is kind of important because it's kind of like the key point of this particular section here that I'm reading. Notice of termination of all leases for non-payment. you can actually, in Georgia, immediately terminate the lease if somebody doesn't make rent payments. The landlord can file for eviction pretty much immediately. Now, the tenant does have, however, 7 days to pay to avoid eviction. So what usually happens, and what I have done, is as soon as the rent is late, I send a letter. There's usually a grace period, so I'm kind of a little bit more lenient than this law. The law is actually a little bit stricter than I usually have been on my leases. I give a little bit of a grace period, maybe like 4 or 5 days, but if after 4 or 5 days no rent payment is made, I send a letter to the tenant with a return receipt, certified mail, so I have proof that the tenant actually got the letter. And in that letter, it basically states, from the receipt of the date of this letter, you have 7 days to make your rent payment or vacate, basically. And that's your 7-day notice, basically. Now, after those 7 days go by, then, I will do the immediate eviction proceedings, or start the eviction proceedings. All in all, eviction in the state of Georgia, if you kind of stick with the schedule and on top of things as a landlord, it has been taking me, non-contested that is, about 4 to 6 weeks. So that's not very long compared to some other areas of the country. And that all depends on how quickly you can get a court date, and if the tenant actually requests to or is going to show up at the court date. Of course, they have a right to make their case known to the judge, and the judge can then decide, okay, well, you can stay another month or so, or whatever. The judge is really the ultimate person that makes the decision. But in most cases, whenever eviction is immediate or impeding, basically, or coming up, the tenants that I've had that were being evicted have already vacated by that time, and so they don't show up for any court dates, and then automatically, of course, I have a writ of possession, basically, so I can take my property back as soon as I can get a sheriff scheduled to give it back to me, basically. So let's talk a little bit about entry, because that's also important. A lot of people in the past have asked me, so when can my landlord go into my place and for what? And how much of the notice do they have to give me? So you really have to you're required as a landlord to give, there's really no statute for you entering your premises, basically. But 24 hours is recommended, and specifically for maintenance and repairs that are non-emergency, the landlord must provide prior notice. 24 hours are recommended. In terms of showing the property, for example, to the next tenant, if the lease is about to be up, the landlord must also provide prior notice. 24 hours is recommended. And the emergency entry allowed is, of course, allowed without notice. So basically, if you have, a fire or, a pipe break or something, then you don't have to give any notice for that. You can just go in and take care of what you need to take care of as a landlord. There's also no statute for entry allowing a landlord to enter during a tenant's extended absence. And usually this is actually something that's written in the lease. If the tenant is absent for 2 weeks or longer without notice, that the landlord can then go into their property and inspect it for whatever reason. And there's no statute that regulates that you have to give any kind of notice. Also, having to give a notice to tenants for pesticide use, there's also no statute about that. Although usually, again, there's a note or something or some sort of information given to the tenant prior to pesticide use, especially if that tenant has children or animals or pets or something. That's kind of like a given thing that you should really do that as the landlord. And again, as I said before, this is actually part of this section. As a landlord, you are not allowed to shut off any kind of utilities for any reason. These are actions that are punishable by a fine, so don't do that as a landlord. Don't threaten your tenants with turning off utilities if that's what you're paying for anyways. And a lot of times with long-term rentals, though, tenants are actually the ones that pay for that, so this is not a really big thing. So yeah, I have a couple more points to make here, and we are getting, time just flies, 13 more minutes. I'm just going to go ahead and go through them real quick. And then want to make sure I get them all in. There's a couple other things that I wanted to basically mention is that a tenant in the state of Georgia anyways, a tenant may not cut or destroy growing trees, remove permanent fixtures, or otherwise injure the property without prior permission. and the tenant may use dead or fallen timber for firewood and pasturing cattle. I never had a tenant that had cattle at my properties, just FYI. So, the landlord responsibility and liability. The landlord must keep the rental unit in repair. The landlord is liable for all substantial improvements made to the rental unit with their consent. So if a tenant decides he wants to, change the toilet out and asks the landlord ahead of time, can I do that? Will you pay for it? And the landlord says yes, they can't change their mind about that later. They have to pay for that. Let's talk a little bit more about destruction of a dwelling. So destruction, this is really weird because this is something I did not know, so I'm going to share that with you guys. And this is actually paragraph 44-7-15 of the Georgia statutes, is that the destruction of a dwelling by fire or the loss of possession by any casualty not caused by the landlord does not release the tenant from the obligation to pay rent. So what that tells me is basically if you're renting a place and it burns down, guess what? You still have to pay rent for it. I'm hoping you have insurance for this. That's all I can say to that. And somebody's going to have insurance for this, because if I can't live there, I'm certainly not going to pay rent there. Flooding disclosure too. So if any portion of the living space covered by the lease has flooded 3 times in the last 5 years, the landlord must disclose this to the applicant before signing a lease. And this is kind of like interesting because I recently did rent a garage, and it has flooded more than 3 times. It pretty much floods every time it rains. So I ended up giving up that garage space and moved my stuff someplace else. But good to know, because no flooding disclosure was given to me on that unit. So, and of course, this last one, also very important, lead disclosure. Landlords must disclose all known lead paint hazards. Landlords must also provide tenants as an attachment to a written lease with an information pamphlet on lead-based paint hazards. Most of the properties that have been built since, I believe it's 72 or 73, I don't know, sometime in the 70s, that's when they kind of stopped using lead-based paint. So any newer property, you wouldn't really have that issue with, but I have had properties that were built in the 40s and 50s, and so I do have to tell my tenants about this. And the pamphlet is easy to download on the internet. You can just print it out and add it to the lease, and at least, your tenants will know that there's a potential that there has been lead paint that was used in that particular property, and so at least you notify them of that. Domestic violence situations, there's no statute for that, and retaliation, no statute on that as well. So, that being said, that brings me to the end of what I have gathered here for the show today on Georgia landlord-tenant laws. And if you wanted to take your case to a small claims court, the limit is $15,000. So if you are in dispute with your tenant or with the landlord, the limit is $15,000. And of course, you can take your eviction cases to a small claims court as well. There's a couple of places that you can go for further information. GeorgiaLegalAid.org is a good place. And of course, there's all kinds of Georgia Legal Services programs, and Georgia Senior Legal Hotline, and Georgia Law Center for the Homeless. All of these links I will provide in the informational section of this show, as well as when the show is uploaded to my YouTube channel. So check that out. My YouTube channel is really easy to find, Julia M. Spencer, but you can also get the show later on the WRUU.org website. One last thing, business licenses. So there's no statewide statute for you to have a business license to be a landlord. However, local cities and counties may have regulations and requirements. So check with your local governing authority. I do know for the city of Savannah, as well as for the Chatham County, there is now an ordinance to get not a business license, but a permit for short-term vacation rentals. I talked about that in my last show, which will also be uploaded to my YouTube channel and WRUU.org. So watch out for that. That's coming up. And that brings me to the end of my show. Yay! Wanted to briefly also let you know, since we're at the end, that the viewpoints expressed in the preceding program were not necessarily those of WRUU, its license holder, or its staff. And I hope this was helpful, useful. Please send me your comments, suggestions, criticism, feedback, anything you have. My email address is realestate@juliamspencer.com. Don't forget the M in the middle. I'm going to play you my currently favorite tune on my playlist. And please join me again for my next show. My shows are on Wednesdays at noon. I try to always have live shows. Doesn't always happen, but I try. And I will replay here in the near future the show on the Chatham County, the new ordinance in Chatham County for short-term vacation rentals. That's also going to be on my YouTube channel, so check that out. And I'll be back again next week, so join me again, and I look forward to hear from you. Have a great Wednesday, everybody. Bye-bye.
For your free guide to real estate investing, visit juliamspencer.com.